This is the Wealth Roundup with Patrick Leonard from the Leonard Wealth Advisory Group of BMO Nesbitt Burns. Any postings and or social media content are the views of the advisor and do not necessarily reflect BMO's position or viewpoint. The information herein is for Canadian residents only and does not constitute any financial, legal, tax, investment, or other advice. Welcome to the Wealth Roundup for the week of July 30th, 2025, with Patrick Leonard from the Leonard Wealth Advisory Group of BMO Nesbitt Burns. Here we are in the dog days of summer, Patrick, and it's time to start talking about estate planning.
Yeah, I suppose there's no other way to kind of turn the conversation after talking about how great a summer is to start talking about what to do when you die. But you know what? When we were thinking about a topic for today's podcast, estate planning really kind of came to the forefront for my team because we have a lot of it going on right now. We have some people doing some pre-planning, and we've had some of our clients that they're now taking care of some estates for family members. So I thought it'd be a great topic. I think that an estate plan is probably represents about a third of the financial planning process, because it's not just kind of the documents that are part of an estate plan, but it's also going and thinking about taxes. It's about thinking about philanthropy, so maybe some charity, but it also kind of explores a lot of the family dynamics, which are kind of different for everybody. So yeah, so it's quite complex, and I think there's certainly some things that we can talk about today.
Probably very important to make sure that your wishes are known to your family members before something untoward happens, or if there's an inevitable old age death that happens in the family or something like that. Let's start with the will.
Yeah, the will. So we always kind of say that the person that is the will is for, or the person that's writing the will. The technical term for their name is the testator. And so if we think about wills here in Alberta, is that you need to be 18 years of age to draft a will. Without kind of getting on the Google machine right now, I think we'd probably find that in a province like BC, where the legal age is 19, is that you probably have to be 19. So you have to be a legal age, because it's a legal document. A will has to be either handwritten or typed. It can't be an email or a text. So a little bit different than, kind of a lot of communication. So there is this drafting process that goes into it. And yeah, certainly talking about the people that are involved, and the people in the case of a will is that we would be talking about beneficiaries. When we think of beneficiaries, those are going to be the people that you're going to receive the proceeds of your estate. You need to take special care to list their complete name and their relationship that they would have to the testator. So it can't just be my bowling friend Frank. It's Fred Smith of this address, and to go and identify those beneficiaries.
Frank's a lucky guy if he's included in a will. That's for sure, especially if he's not part of the family. So there, the will, and again, you said handwritten or typed, not texted or in an email. So I can't do a TikTok reel and have that as my will.
Not yet. Not yet. But you know what? I think in the future there's going to have to be some evolution, and we have seen here in Alberta some advancement in the process of dealing with estates. So we used to use kind of the time frame that if you're somebody who is settling somebody's estate. So the settling is the word that we use to kind of talk about, now that somebody has passed away and we now have a will, is that now we, need to follow those directions. It would be easy to say that it would take almost a year, sometimes 2 years for a complex estate. So, you kind of had talked about, having the conversation with people that are involved with the will and the estate. And I think finding the right time to have that conversation, probably really difficult. But if we think that a good time to do a will is either when you turn of age or when you've had kind of a major life event. So, I think probably most people would say that the first will that they ever did was probably when they got married, and that the second will that they did probably maybe once they started a family. And then, as they kind of age, it could be maybe they started a business or sold a business or had some grandchildren and became more thoughtful about what their legacy was going to be. And so I think that probably, once you kind of get into this, it's probably that second stage now where you you're thinking about your estate, about your legacy. And, somebody that I used to work with used this word, some control beyond the grave. So you have kind of often if, you're a parent, you're kind of always a parent. You're always thinking about your kids. So even this idea of thinking about them once you're dead is, having this conversation with your family members that are going to be part of your estate and letting them know what some of your plans are, and perhaps even kind of asking them if they have any thoughts about an estate, because there may be some things like some certain items that people want to make sure kind of stay in the family. And I think we think of big items like maybe a farm or a cottage, something like that, but it could be that painting on the wall that people just kind of remember because it was always there at the dining room table. That might be something that people want to pass on to a certain member of the family or a friend who they know that would appreciate it. Having that conversation would be really key.
You mentioned control after death. What about power of attorney for someone who is still living?
So two types of powers of attorney. You have one type of power of attorney that deals with, call it, your financial affairs. So you're alive, but perhaps you're incapacitated. So you would have either a power of attorney that would come into force under certain conditions, probably when somebody loses capacity. And that loss of capacity in most cases has to be determined by at least one doctor, but often it's two doctors. And then there would be the other part of the power of attorney, which is kind of like a living will, a personal directive, where being able to communicate with your medical representatives to kind of talk about your treatment in the hospital and what kind of procedures you want the doctors to do when they're caring for you. And so the power of attorney document, you can, what we usually see is that once a person has probably some more advanced estate planning, probably when they are a little bit older, either there's more of a sophisticated or bigger picture with regards to their finances, or perhaps as a person is getting older and they just know that, they're going to start to, over time need some help, maybe from some family members. Documents like the will, documents like the power of attorney, typed or handwritten, witnessed by two individuals of legal age in the province, and that all parties have to be signing these documents while they're present, meaning you can't sign it yourself and then leave it at the law office and have the lawyer go in and witness it with their say their paralegal. The other part of the kind of this control beyond the grave is, we talked a little bit about charity, thinking that might be a big part of kind of an estate plan is making a contribution to charity. One thing we'd like people to kind of think about when they're doing their estate planning is perhaps making their contributions to charity before they pass away. There's some significant tax benefits to the testator, the creator of the will. Those benefits can be amplified if they're done before the person passes away. And then the second thing is, you often hear people talk about trust. Trusts would be, think of it as creating another entity other than the testator. And often where we see trust being created is either people that have a lot of wealth, and there are certain things that are part of that wealth that they want to keep in the family intergenerational. So think of that again, a farm or a cabin property, something like that. They want to stay in the family. But we also see trust set up for other reasons. If, say, the parents kind of look at their family situation and maybe they have somebody who they want to give some money in their estate to, but they see this person has some difficulties in life, some challenges in life, and they may be bad with money. So we often call this a spendthrift trust. They receive some money, put into a trust, and then there's some controls that are put on that trust so that the person can't spend all the money that they receive. You see often, maybe a family member that's dealing with an addiction, or maybe is at risk of a marriage breakdown, or is maybe in a situation where they might be going through a bankruptcy. And again, the parents, the testator that's creating the trust, kind of wants to insulate the assets that would be coming to this person via the will and put them in a trust, which is a vehicle which can provide some protection for those assets as they're flowing through the will and out to the estate.
There's all kinds of tax implications and things that come into play as well. So all the more reason to contact you through your website and find out more about it. And it's never too late to start, right?
Absolutely.
Very good. The Wealth Roundup for the week of July 30th with Patrick Leonard from the Leonard Wealth Advisory Group. Very good. Thank you, Patrick.
Thanks, Terry. Have a good week.
This has been the Wealth Roundup with Patrick Leonard from the Leonard Wealth Advisory Group of BMO Nesbitt Burns. I'm Terry Evans. The Wealth Roundup is part of the Reluctantly Podcast Network.